is Judge Susie Norby. I'm an elected trial judge in Clackamas County with my courtroom in Oregon City. I've been an elected trial judge for 8 years after a legal career of 15 years.
My name is Karen May. I'm an attorney and I do volunteer work with local nonprofit organizations like Cluster Law Project.
Tim Garrison, I'm the chair of the history department at Portland State. Good afternoon.
And would you please introduce yourselves for us?
Good afternoon, I am Claire Wilson.
I'm Maria Carlson.
I'm Jake Robertson.
I'm Michael Van Sant. And I'm Maxwell Lutz.
And our coaches are Nick Kallstrom, Maureen Leonard, and Reeves Kissler. And our teacher is Miss Portia Hall, and we are Unit 3.
Thank you. I will then get right to reading the question. How has the Constitution been changed to further the ideals contained in the Declaration of Independence? What are the basic differences between the adversary system of justice, used in the United States, and the inquisitorial system, used in most European nations? The theory of the adversary system is that through observing the presentation of evidence and agreement favorable to each party, the truth will become apparent to the jury or judge making the decision. How well has that theory been substantiated in practice? What evidence can you offer to support your response? What procedural safeguards in the 5th and 14th Amendments ensure a fair trial for defendants in the adversarial legal system? You may begin.
The adversarial and inquisitorial system, although quite different, have proved equally as stable throughout the years. Each system has its flaw and a different way of eventually finding the truth. The difference between the inquisitorial system and the adversarial system is their separate focuses. While the inquisitorial system is goal-oriented, the adversarial system is process-oriented. The adversarial system and the inquisitorial system are the same in the fact that they are essential legal systems for their respective nations. However, there are many differences in these two judicial proceedings, such as one system's drive to obtain the truth and one system's goal to protect the rights of an individual.
The adversarial system used in America has a core value of staying as impartial as possible, contrasting that of the inquisitorial system used in much of Europe, which intends to find the whole truth. There are many safeguards in place to keep the extensive process that is the adversarial system on track. With both of the systems come drawbacks, but one more so than the other. With the adversarial system of America, the long process involved in the system is conducive for potential mishaps. While on their mission to obtain the truth, the inquisitorial system has fail-safes to ensure this obtention, some of which being the non-existence of self-incrimination rights, a judge who works in cohorts with investigators to find evidence, and no presumptions of innocence. Now with these fail-safes, there are circumstances that may arise calling the integrity of the system into question. Much like its counterpart, the adversarial system has potential for wrongs.
By contrast, the adversarial system has many procedures in place to benefit the individual on trial, such as a judge that remains neutral, evidence codes that inhibit certain evidence from being offered, and even a chance to overturn an unfavorable decision in the Court of Appeals. For example, in State v. Reineke, the Oregon Court of Appeals overturned Michael Reineke's murder conviction because the prosecutor commented on his choice to remain silent. This violated Reineke's Fifth Amendment right to remain silent. In the inquisitorial system, Reineke's silence would have been proper evidence to use to convict him of murder.
During trial in an adversarial system, each party is represented by a lawyer and presents their best evidence to a judge and jury. The jury is populated by randomly selecting people of voting age, which minimizes the risk of discrimination and corruption. Among the rights granted by the 5th and 14th Amendments are the right to remain silent, recognized by Miranda v. Arizona, the 6th Amendment right to appointed counsel, recognized in Gideon v. Wainwright, and applied to the states through the 14th Amendment. The 6th Amendment right to confront witnesses against you, redefined in Crawford v. Washington, and the right to not be put in jeopardy twice for the same offense.
Both the inquisitorial and the adversarial systems have their strengths and weaknesses, as you may expect. However, they both serve their purpose of finding justice. The inquisitorial system focuses on finding the truth, no matter the path it must take to get there, or whose rights may be infringed in the process, while the adversarial system spends much more time during an investigation and a trial protecting the rights of the accused. That is why this system is much more process-oriented. The two systems have very different ways of reaching their end result, although they have both, for the most part, served justice quite effectively. We are now ready for your questions.
Thank you. You may begin.
Some critics allege that the adversary system makes an American trial an expensive and uncertain undertaking. How would you respond to that criticism?
I would personally agree with that criticism, such as a circumstance like the OJ case, where he was able to dramatize the situation in the courtroom, which ultimately helped him win the case through things such as the glove not fitting, which would in essence be, he would be able to manipulate the glove in a way that puts restraints on the jury that ultimately helped them return the verdict in which they did.
Additionally, the adversarial system, it can be, like you said, it can be more expensive, but also it takes longer time than in the inquisitorial system. The inquisitorial system, they go through cases faster, mostly because the judge is more investigative. They are the investigator, they are hands-on with the case from the start. When in the adversarial system, the case is brought to the judge and each side defends their role.
I would have to disagree with my colleagues. I would say that it would be incorrect to define the adversarial system as uncertain, even if it may be more expensive. In the inquisitorial system, the way that a small number of people, a judge, which then compiles a dossier of evidence and passes on to another judge to make a decision, allows for a small number of people to kind of shift it in which way they see. The fact that they don't have as many evidence codes means that we're not as certain of the validity of the evidence or how it was obtained or where it might have come from. And so we can't necessarily be as certain that those rulings are correct as we can in the long and admittedly expensive process of the adversarial system.
All right, next question.
I am curious as to the history of these two systems. Can you tell me a little bit about how each system originated, briefly?
The adversarial system originated from England. England also had an adversarial system, but when we adopted it, we added on the what we call procedural safeguards or individual rights, and some could say that those were due to how the British treated our colonists.
Was there a time where they were, that both the continent of Europe and Great Britain used the same systems and they diverged, or did they develop their own track?
The inquisitorial system of justice, which was commonly used in Europe for most of its history, originates in, for the most part, in Roman and then later Catholic practice of the Catholic Church. The term Inquisition was not only used by the Church to determine things like heresy, but was sometimes used in the same way, where a priest, or later on when it became used as more of a legal system and less as a religious system, a magistrate would investigate the trial and make the decision. As time has gone on, those systems have modernized, just as the adversarial system has modernized. But it finds its roots in both the Catholic religion and in monarchy as an institution.
Thank you.
Humans are naturally emotional and not neutral. How does the fiction of neutrality affect the potential effectiveness of either system or both?
In an adversarial system, with the use of juries, who are randomly selected people from the society, they're much more easily swayed through dramatizations and much more emotions given from the attorneys of both sides. So that can affect the decision made in the adversarial system.
I would argue that they both fall prey to the emotional nature of people, but in slightly different ways. While I think the more televised and open nature of an adversarial trial, as well as the fact that there are 12 lay people making the decision, allow the counsel and the defendant, or just as easily the prosecution, to play on emotional issues more than actual evidence to try and sway the jury or even sway the public if it's a televised or just widely publicized trial. But I think that in the inquisitorial system, the emotions and the biases of the small number of judges who make the decision can play a huge part. If this one judge who's the only person who sees your trial, or the one judge who's the only person who directs the gathering of evidence, has a reason they dislike you, has a bias against you for some reason, that could make a huge impact, possibly larger than a jury that's been convinced of your sob story could.
Thank you. Next question.
If you were a criminal defendant Would you rather be tried in the adversary or the inquisitorial system?
If I were a criminal defendant, I would personally rather be tried in an adversarial system due to its protection of individual rights, such as the case in the Emmett Till murder trial. By getting a jury, he was able to pool a population that was biased related to ethnicity when a black individual was killed, black individual youth was killed, which ultimately allowed the two suspects to walk free and later actually admit to Times Magazine that they were the murderers, and such is the case in the O.J. Simpson trial.
I would disagree with my colleague. If I was a criminal defendant, I would rather be tried in the inquisitorial system because I would prefer a system where the truth couldn't be lost through a process, such as in the adversarial system we have exclusionary of evidence where because of someone who is not me, is not the criminal defendant, makes it flaw in the process that is so valued in the adversarial system that a truth that could somehow protect my future as a citizen that could be excluded is definitely something I value, and that's why I would choose the inquisitorial system.
How would you
Cut
say
you off there, I'm sorry. We need another question.
Well, I'm curious, you maybe only have the chance to answer yes or no, but should U.S. courts use precedents from Europe or from the inquisitorial system? I didn't think I would get there. It's all right.